right. Okay. So today's speaker for today is Tom Crishon, and I'll let him tell you his title.
Thanks, Sean. Hi, everybody. For those who I have not met, my name is Tom Crishon. I'm the Chief Legal Officer at the Arc of Indiana. And a few months ago, I think Noah and Aaron and Sean wanted me to come on and talk about a lawsuit called Texas v. Kennedy. When I said I was going to do that, there was other things going on, and now there's been more developments that I can tell you about. So it's a good timing for me to come on and talk about this. Have you guys talked about the Texas v. Kennedy case, or have seen any other nationwide advocacy on that case?
I don't think so.
No. Okay. It's
Yeah, I don't
probably
believe we've covered it on here yet.
okay. Then I'll go over the whole of it, but there's been a lot of advocacy nationwide on this case. So let me just go on the background of it. In May 2024, the federal agency HHS issued a rule, a new regulation. And you can think about rules like so it's a pretty good framework. There's Congress passes the law, and the law is really kind of say the main idea. And then the federal agency that oversees that law can issue a regulation or a rule that really gives it more meat and really instructions on how to comply with the law. And so here, the law is Section 504 of the Rehabilitation Act, and it's been around, since the 70s, and it's really the main idea that says you cannot discriminate against people with disabilities or because of disability. That's the main idea of the law. In May of 2024, HHS issued an updated rule that gave more meat and more requirements on how to comply with that law. It was a very good rule. It really put some details in on more clarification on how you define disability. Um, when you talk about how websites and applications on the phone need to be accessible, it tells you exactly what that means to be accessible. Um, there's a requirement that you cannot discriminate against somebody with a disability in medical treatment. That was in the rule. And then the other big thing that was added to the rule was called what we know as the integration mandate, which really has roots. And if you remember, if you've ever heard of the Supreme Court decision called Olmstead, I'm sure you guys have talked about Olmstead. So Olmstead basically says that if an individual if it's appropriate for the individual to be served in the community, the individual wants to be served in the community, then they should be served in the community, right? So that's the Supreme Court decision that really found that in ADA, and they're basically saying in that decision that if a state has policies that prevents this from happening, that is discrimination under the ADA. So it's a very, very good Supreme Court decision, and we've used that. Lawyers have used that over the years to really apply it to many different situations. And so that piece where an individual must be served in the community, it's called the most integrated setting appropriate for the individual, called the integration mandate. So what this rule did is take that requirement that we found in court cases and put it in the rule. So it's, again, a really good rule. May 2024, they issued this rule, has all these good pieces. And if you remember, May 2024, that was the Biden administration at that point. Okay. In early 2025, right before the administration changed, there was 17 states that came together to sue the United States government on this final rule. And at that point, what they were concerned about is a small mention in the very introduction of the rule. Now, introductions of the rule don't really have any legal standing at all, but they mentioned in the introduction of the rule when they drafted this that gender dysphoria might be a disability for purposes of Section 504. So they're not saying that it is, it's never been found to be, but they're saying in the rule, you should explore it. And the 17 states didn't like that piece. And so they sued the United States government on that piece, saying that piece is inappropriate and it shouldn't be in there. So obviously, in about a month later, the president changes. So we go from the Biden administration, who drafted the rule, to the Trump administration, who now has their Department of Justice, who defends the United States in lawsuits. And so since that changed, all the parties, all the states in the United States government, with the new administration and the new president, agreed to just put the whole lawsuit on pause and see if they can figure this out. Okay. And so in 2025, there hasn't really been much action. HHS, the federal agency that issued this rule, put some more clarifications out that basically said that introduction is not true, and that for Section 504 discrimination, gender dysphoria is not a disability. And so they clarified what the 17 states were really mad about to begin with. And so this was happening in 2025. In January of 2026, 9 states now, so 8 of the states that were involved, because of what HHS put out and clarified what they were upset about, they got out of the lawsuit. 9 states remained and filed what's called an amended complaint. So their initial lawsuit, they changed, and they've refiled it with the court. Indiana was one of those states. And since the initial reason for the lawsuit, which was this introduction to the rule, was no longer there, what they put in the lawsuit was that they want to make the whole final rule for May 2024, so the updated definition of disability, the web accessibility requirements, the medical treatment discrimination, and this integration mandate, the most integrated setting, so community-based care as a requirement under the rule. They wanted to make it all go away. They wanted to invalidate it and call it unlawful. And so this was a concern with many in the disability community. And there's really been a nationwide push to try to get them to drop this lawsuit. Those are all very good things. It's a good rule. And so there's been a lot of advocacy with state organizations, with self-advocates, with national organizations trying to push to figure out if we can get rid of this lawsuit. And so that's kind of where we were up until when I agreed to come on and talk a couple months ago about this lawsuit. But since then, part of the advocacy that we've been doing at the Arc of Indiana is trying to outreach to the Indiana Attorney General, Todd Rokita's office, about this lawsuit, because since Indiana is suing on this lawsuit, then it's the Attorney General who's the attorneys on it. And so we were trying to contact his office and say, hey, we think this is a bad idea and this is why. And so in March, right after it was refiled in January, we had sent a letter and said, this is a bad idea and this is why. And he agreed to sit down and have a conversation. And so in March, I sat down with the Attorney General, his chief deputy, the second in command, and what's called a solicitor general, which is the main person who is on the lawsuit, is the main lawyer on the lawsuit. And we talked for about 45 minutes. And we talked about this lawsuit and the concerns I had with the lawsuit about, these are really good protections for people with disabilities and how it's a really good rule. And you're signaling to your Indiana being in the lawsuit is showing that maybe you think that this community-based care is not a good thing. And that's a bad thing if you think that. And even if India is in it, that's a bad thing. And so we had conversations back and forth. And ultimately, eventually in April, end of April, they contacted and asked for another meeting, and they agreed that they would take Indiana out of the lawsuit. And so end of April, Indiana withdrew from that lawsuit. So that would leave 8 states now. And then about 2 weeks ago, South Dakota withdrew from the lawsuit. And so now it's down to 7 states. So the lawsuit is still going on. It's in Texas is where it's being, what court it's in. So it's something we're certainly tracking, but it's a really good thing that Indiana got out of it. Indiana being in the lawsuit, which is basically trying to argue that community-based care isn't required, is a bad thing. So we didn't want Indiana to do that. And so them agreeing to get out of the lawsuit is a really good thing. And I know we've had a lot of people contact the office from a nationwide standpoint in Indiana, and all of that advocacy clearly worked. And so that's a really good thing. Again, 7 states remain. We'll see if any other states kind of decide to get out because Indiana and South Dakota got out. They might. If not, then they'll just continue with the lawsuit and kind of we'll see where it goes. Certainly, advocacy is not going to stop. The lawsuit's still going to continue, but at least our state's not in it, which is a good thing. I think Noah and Aaron specifically wanted me to kind of talk about that lawsuit. You've probably seen some communications. I know there's emails going out and websites and meetings being called about this and about advocacy about this case. We wanted to share kind of what was going on, and I'll be happy to answer any questions anybody has.
Audio now unmuted. I have a question. This is Lexi.
Lexi.
My question is, okay, so first of all, somehow it doesn't surprise me that it's Texas versus Kennedy, because Texas does a lot of stuff like this, unfortunately, which leads me into my question. Is there an arc of Texas, and are they fighting their own state for being basically the leader of this lawsuit?
Yes, there is, and they are. Texas is very stubborn in these regards. Texas is very different than Indiana. Texas still has state-run institutions. We do not. And that was part of the argument I was making to our attorney general, is saying this is a Texas lawsuit. This is not an Indiana lawsuit. The things that you are trying to argue against are things that we have accepted in the state of Indiana for the last 20 years. And we cannot move backward. And so, yes, I think that Texas is not going to, I do not see Texas as willingly getting out of the lawsuit. I think that it'll be better for the other states in the lawsuit to still try to get out. But I can see Texas needing a court to say they're wrong for whatever reason. So, but yes, advocacy is happening. I've had conversations with 3 different states in the last 2 weeks from advocacy groups saying, okay, let's learn from what you guys did there. What can we do? And I've had conversations to try to, share what we did that was, successful, to try to help them with their conversations with their attorney generals. And that is absolutely happening in Texas too.
Wait, I have a question. I'm Katie from Zionsville, IAA. So how can we get to that level? Because right now, with our group, we're still trying to fix things, but how do we get up to that level so we're consistent and still doing things like that?
Like with the attorney general's office?
Yeah.
I think that, you have to start with sending communications and building relationships, right? So I've heard of many organizations that have reached out to the attorney general's office to try to have a conversation with this, and they weren't getting responses. They weren't getting meetings. The Arc of Indiana got a meeting, and the reason is because we have built that relationship over the years. And I think that we talk about, from a advocacy standpoint, how important it is to build relationships with decision makers, with office holders, with legislators. It's getting them to know you, who you are, what you're concerned about, and that you can be a resource to them. When they have questions about something that they can come ask. And so I think that the Arc of Indiana has just built that relationship over the years. We have Attorney General Todd Rokita at our Valentine's Day at the State House every year. And I've honestly, the last 2, I've talked to him about this case. I pulled him aside and had a face-to-face conversation. And that's what turned into the invitation for a 45-minute meeting with him and his deputy and Solicitor General. So I think more than anything, it's building relationships. But it's sending communications. It's in this situation. If the self-advocates wanted to send a letter to the Attorney General's office and say, this is why we're so concerned about this, obviously it's not needed anymore. But in a similar situation, that's a really good step. And, communicating the concerns, but also the thanks, right? So it's not always a good idea just to go when you have a problem. It's when they do something good. And this is something that we did after they dropped the lawsuit, is we put out a press release saying, we appreciate the Attorney General's office. The Attorney General's office did not need to sit down with me for 45 minutes and have these conversations. They did not have to contemplate. They could have just stayed in the lawsuit, but they decided to get out of it. And so we want to congratulate him and thank him for that decision. And so that's going with the whole building relationships, right? And so I think that's the most important thing you can do with both your local legislators and statewide legislators is, ask for meetings, talk about issues you're concerned about, tell them things you're concerned about, thank them when they do the good things, and just kind of continue just to build that relationship.
I will say that I kind of know Todd Rokita, because he and I have done some public speaking together. So I think for us is maintaining that relationship and to keep it growing.
Absolutely. And when you do that and you send him a letter about something or you see him somewhere, you could be like, hey, you remember we did this speaking thing together. So he can remember you and kind of build on that relationship. But you're absolutely right.
And it's the same way with Becky Cash too.
Yep. Yep, exactly. Your local legislators are very important to build that relationship with.
Yeah. She just happens to go to church with me.
That's even more helpful. Yep. Any other questions on this?
No questions, Tom, but I just looked up because you said that they have a lot of institutions in Texas.
Yeah.
They have 13 large campus-like places.
Yep. Yeah. It's they are still fully embraced in that model of institution, which again is why they're so concerned about it. The federal government making this a rule that they have to kind of upend how they do services is a concern in Texas. And that's why they're wanting to be. But again, why Indiana should not be, right?
Is Texas concerned about money? Is it a money thing ultimately because they get these institutions get Medicaid dollars or whatever, like state and federal dollars, like probably if it's if it's anything like how Indiana has the group homes, like I think they get Medicaid dollars, but they also take like almost all your Social Security. So is it
Wow.
basically is what at least one of the things, is it a money issue?
I honestly don't know. I don't know what the decision is. I don't think Texas ever pushed toward community based and is backtracking. I think they've always stayed in this model. So I'm not sure what their cost is per day or anything, how that would compare. It's
Uh,
just something that they've embraced over the years, and that's why they're so interested in the new rule.
right, because I think research has shown that it actually costs more for an individual IDD to live in an institution.
Oh, it
So
is.
maybe
Yes.
they're concerned about like losing the money.
I possibly. I'm not. I don't know the reasoning. I'm not sure.
Thanks.
Hmm.
Which kind of kills me a little bit because their governor has a disability and is in a wheelchair.
Yeah. Yep.
So it's going like, I don't know if I want to say his standards, but it's like he should think about how he would want to be treated because he's in a wheelchair.
Would
Yeah.
they call that like a catch 22 or a
Yeah.
double standard or probably a
Uh,
double standard? Seems like it's a double standard.
and just FYI, there's the states that are still in it are Texas, Alaska, Florida, Kansas, Louisiana, Missouri, and Montana.
Somehow Florida doesn't surprise me either.
Hmm.
I don't know why. And also kind of Louisiana too. I feel like some of these states that are doing this are just, I think it doesn't surprise me because just overall, in general, they're very behind the times in how they do things. They're very old school. And I
Mhm.
feel like a lot of these states, like Montana's super like rural and they're really old school. Like I feel like a lot of the states that are in this are states that aren't like as advanced in like I don't know, just like in their thinking, I guess, about just in general, like they're very behind the times.
Yeah, we were hearing that Louisiana might be willing to get out, but we haven't heard an update since. So, but yeah, I think that's, we'll kind of see what those states do going forward.
Yeah, I'm curious myself.
Mhm.
I think when it's down to the wire, if more withdraw, I think when it's down to the wire, I'm curious to see who's left. You know what I mean?
Yeah, for sure.
Okay, so s- okay, Sean and Noah, if you guys are okay with this, maybe as SAI can wrap around this and as SAI, what can we do to help these other states to get out of this on what we are talking about?
I don't know. I don't know what now. I think that, a lot of the legwork now has to happen within those states. And so the organizations that are within the state, whether it be kind of like Lexi mentioned in the ARC, or if there's a self-advocates chapter, maybe if you guys want to kind of reach out and see, I don't know if you have relationships with self-advocate chapters in other states, but that would be something, and see what kind of support. But at this point, it's encouraging them to kind of move forward and have those conversations. And that's what I've been doing as states reach out to me. I think I just talked to Kansas, Montana, and one other state in the last week. They're just trying to get ideas and figure out what they can try to do. So certainly, if self advocates chapters reach out to you all, have that conversation and see how you can be best supportive to them. But the work really needs to happen in those states now.
You know what that makes me think about? I don't know if the lawsuit will still be going on when this is, but when the ARC has their national convention, self advocates and ARC staff and stuff, and um like it brings everybody together from different states.
Yeah,
And stuff like that is a good place to have those kinds of conversations when you're at like a thing that other
absolutely.
states are
Yep.
there and stuff like when it's disability related and it's people as passionate about it as we are.
hmm That's a really good idea.
Tom, the states that you said were Texas, Alaska, Florida, Montana, Louisiana, and what other states?
Kansas and Missouri.
Kansas and Missouri. Okay,
Those
thank
seven
you.
states are left.
Doesn't Kansas and Missouri border each other?
Yes.
I
Yeah. So
wonder if
interesting is the federal appeals courts are divided into circuits, and each circuit has a few states that they control, and they kind of make their own decision until the United States Supreme Court tells them otherwise. And so the Fifth Circuit is Louisiana, Mississippi, and Texas. And so the Fifth Circuit Court of Appeals has a different opinion on some of the Olmstead stuff as the other circuits in the country. And so I think that's part of the reason why Texas and Louisiana are involved here, because their circuit court is telling them kind of one thing on one of those Olmstead pieces. But yeah, I don't know why the others have kind of hopped on. But yeah, those two are close. But just a note on why I think Texas and Louisiana are definitely involved.
is Kansas and Missouri part of the same circuit court?
Kansas and Missouri. I don't remember if they're in the same circuit or not. They're not in the Fifth Circuit, but I don't know.
Right.
I don't know what circuit they're in.
I'm just curious if like how many circuits have
They're actually in
multiple.
separate states. They're in separate circuits, Kansas, Missouri.
Okay.
Yep.
Because my curiosity was like how many states that are in this or happen to be in the same circuit and are hearing the same thing from their circuit.
Yeah, well, no, it's just the Fifth Circuit. Fifth Circuit's so okay. The part of there's many parts of Olmsted that have been expanded in courts over time. But one of the pieces is called the risk of institutionalization. And so Olmsted found that someone actually in an institution who can and wants to be served in the community but was not, that can be discrimination. It has been expanded in courts to say the risk of being institutionalized is enough. And so that's been a really good thing for us as advocates to say we don't care if they're actually in an institution, but this policy is going to make a greater risk of them being institutionalized. And that is a discrimination under Olmsted. Many circuits, most all the circuits who have talked about that have found that that Olmsted is expanded to include risk of institutionalization. The Fifth Circuit did not. The Fifth Circuit said risk of institutionalization is not enough. And so the Fifth Circuit is more kind of constraining on what the Olmsted protections are, which I think is why Texas and Louisiana specifically are concerned about it being expanded out of there. But to give you a sense of it, so let's see, Texas is Fifth Circuit, Alaska's 9th, Florida's 11th, Kansas is 10th, Louisiana's 5th, Missouri's 8th, Montana is 9th. So they're pretty spread out on kind of the central to west. None of the East Coast ones are involved. Noah?
I was just going to add to if you guys would like to get connected with other self advocates nationally, a really good opportunity is the National Council of Self Advocates has a public call every month, and that would be a really good opportunity to meet with other groups and make those connections. As well as Melody Cooper here is on the SAI board, which is another of our national equivalent. So if you guys, would like to get in contact with her, I'm sure she knows some other groups as well, and so would Sean.
Mm-hmm. Yep.
Like, is it possible, like, to do like a Zoom call during our meeting, as so we can talk to other groups?
What? Who? Who would you want to talk to?
Well, the other self-advocate groups, either nationally or state or
Thursday.
whatever.
Okay, so on Thursday at 1 o'clock in the afternoon our time, they also have a meeting they call SATEC. I don't know if y'all know anything about that. Becky might be able to send the link out, but there is a meeting, and that's a national group. And on that meeting is about 30 or 40 people on that meeting every week. They talk about different issues. They talk about different things. So maybe if y'all can get the link from Becky, maybe you can join Sunday and listen to some of the things that they say. Like I said, Sunday is every Thursday at 1 o'clock our time. And it's usually about an hour from 1 to 2. So yeah. So that's a good way to get kind of hooked up. Because there is a lot of people from that area. I mean, I get on there when I can. It's not every Thursday, but when I can. And there are people from all over. New Jersey, New York, California, Hawaii. Some of the states that Tom mentioned also. Yep. So maybe if you could get with Becky and ask her for the link and hop on there on Thursday. Cause that is a good way to get connected with a lot of people. Yeah. And then like he said, SAVE, SAPE, Self Advocate Becoming Empowered. That's a national organization. So yeah, there's a lot of ways out there. If you really want to get connected, yeah, there is a lot of ways.
Okay.
That's two. Here's the third one, which I'm
Yeah.
an officer of. National Council of Self Advocates is also they also have a public meeting where I can send out that information to you guys, and you guys can come on there, and they're from all over the country that get on there. So, and there's Noah, how many gets on there? 100,
Probably,
maybe
yeah, probably
70,
120 somewhere along that.
and it's also from people that the states that Tom mentioned.
Yep.
And next Wednesday is the meeting.
Mm-hmm.
Okay. Is there any groups that meet in the evening?
You mean from other states?
Yeah. Or anywhere?
I have no clue.
I have no clue. The only one I know of is Star Trek. So yeah.
Yeah, the only thing that I can tell you, and probably Noah and Mel can tell you the same thing, is just come on those meetings that we mentioned and ask.
Yeah.
M-
That would
Because
be the best. Huh?
we typically meet like on the first Monday of every month. But I can jump on at any time if I'm not working or like on my break or whatever.
Well, like we just tell you, hop on Star Trek.
Yeah.
Star Trek is on tomorrow at 1 o'clock. Anybody else have any questions for Tom?
I will bring this up to my group / officers and see what they think.
Okay, cool.
And
Okay.
either as officers or as a group, or if no one wants to do it, I can do it and then report back to our group.
Cool. Well, thank you, Tom.
Absolutely. Thanks for having me. If anybody has any questions, feel free to reach out, but be happy to come anytime. But I'll let you all continue with the meeting.
All right. Thank you,
Alright.
Tom.
Thanks, Tom.
Thank you.
Tom.
Thanks,
Thank
everyone.
you.
Tom.
Bye.